Hey, Laura.
Hey,
Hi, Ray.
Hello, how are you?
Fine. I recognize you in your car with your hat on.
Yes, indeed. I'll be at the house here in just a few minutes, but I thought I'd go ahead and jump on. I had a group meeting this morning.
No, that's fine. We're having some technical difficulties, so that's the way that goes, right?
It does sometimes. They're like technology's like puppies. Sometimes it obeys, sometimes not.
Yeah, pretty much.
Suzanne, do you want me to go ahead and get started?
Yeah, I'm going to do the answer to that is yes. Let me do a quick introduction of you, and hopefully Ward will be able to come in. Um,
Okay.
Welcome, everyone. I'm Suzanne Bernritter, and I'm Director of Collaboration with CoreScore here in Manhattan. And today we have a very quick and tight schedule in terms of a special seminar. Two attorneys are going to be presenting this seminar, maybe one because we are having some technical difficulties. Eric Anderson specializes in taxes, estate, and business planning. Ward Hobson specializes in intellectual property law, litigation, business, and corporate transactions. So with no further ado, take it away, Eric.
Okay, first, I'm going to try and share my screen here. And can everybody see that?
yes,
Okay. Um, the Corporate Transparency Act is a brand new act that went into effect on January 1, 2024. It was uh, actually promulgated 4 years ago, 3 years ago, in 2021 as part of the National Defense Authorization Act. And it had, sometimes legislation has, it's passed and then the effective date isn't until a little bit later on. This is one of those. That doesn't happen often, but it does from time to time. This is one of those. And then this presentation, a lot of times when I do PowerPoint presentations, and you've seen others where there's nice, fancy, pretty colors and shapes and all that sort of thing come flying in. This is a book report. It's just, some of us are old enough to remember the show on TV, Dragnet. And Sergeant Joe Friday was known for his tagline being "just the facts, ma'am." And that's what the intent of this presentation is. It's not flowery, it's just the facts. Okay. So with that, the whole purpose of the Corporate Transparency Act is, as I've got a statement there from the U.S. Chamber of Commerce, and what they're trying to do is get at the scoundrels of the world who have created elaborate Ponzi schemes, basically using shell companies, corporations, LLCs, limited partnerships, et cetera, for money laundering, tax fraud, cryptocurrency, all kinds of crazy stuff to avoid taxation and money laundering. And even though all of these entities typically get filed somewhere, there's no central repository, if you will, for US documentation like this for high level deep dive audits to determine, okay, where is this money going? What can we get at? What's legal, what's not? That's what this Corporate Transparency Act is designed to address. My opinion is, and this is just Eric shooting from the hip, the goal here is laudable. I'm not sure the practicality of it is going to elicit the results that they want. They may be killing a gnat with a sledgehammer. Time will tell. In the meantime, we have it and we have to comply with it. So first thing is, who is impacted by the CTA, Corporate Transparency Act? And the general rule is, if you're a company that files to create your existence by filing a document with a Secretary of State or a state, you're covered. Corporations, LLCs, limited partnerships, registered general partnerships, you're covered. Unless you can find an exemption, and I'll go through the exemptions here in a little bit. Unless you can find an exemption into which you can pigeonhole your company, you're covered. What does that mean? Well, we have to report certain pieces of information about the company. We have to report certain pieces of information about who created the company, who organized the company. We even have to report certain pieces of information about who helped create the company. For example, if I create an LLC for a client and I file the document with the Kansas Secretary of State's office, or if I have my assistant, my legal assistant, enter the information and hit the send button on the computer to file that, then we are constituent reporters. There's a phrase that is used that we have to put our names into the database of helping these entities get created, and we have to report that information. So when you report, as we'll show here in a little bit, the entity is the Financial Crimes Enforcement Network. The acronym is FinCEN, FINCEN. I now have a FinCEN number. My legal assistant has a FinCEN number, so that when we fill out documentation for clients, we park our number in there, and that automatically pulls up our information, our personal information, so that we don't have to re-enter it all the time. Here's an interesting tidbit. Even though the legislation itself says that lawyers, accountants, financial advisors can help entities file with FinCEN, the accounting world has opted out. And the reason why is that the reporting is not going to the IRS or a state taxing authority of any kind. And so there's a concept called unauthorized practice of law. And the accounting world, particularly the boards of accountancy of the various states, have taken the position that this may be, quote, unauthorized practice of law. And so they have sought advice from local attorneys general. I understand in Kansas, the Board of Accountancy sought a specific AG opinion, and the opinion is not going to be forthcoming. I don't have a quote on that, but my understanding is that the AG's office in Kansas has said, we're not going to issue an opinion on that. So as a result, accountants are saying, hands off, we're not going to file these things. Clients, you need to either do it yourself, which is not difficult, or get your lawyer to do it. So, so when we file for the reporting company, and then we file information, what information or who do we have to file for? We have to file information about companies, about the people involved in the companies who own 25% or more, or, and this is where it gets to the practice of law, who have substantial control of the company. What the devil does that mean? It's pretty easy to determine who's got a 25% ownership. You either do or you don't. And that ownership is either through actual outright stock ownership, or voting or non-voting stock ownership, or if you have voting rights, you've got ownership. But the substantial control is a little bit of a subjective criteria. The best example I can give you is if you've got a corporation with a board of directors of several people, and a member of that board of directors is a really, really learned person. They have a lot of influence in the operations of the company. They're not an officer. They're not a 25% owner. But when people talk, they listen. You know, the old E.F. Hutton commercial, when E.F. Hutton speaks, people listen. If you've got somebody in the organization that doesn't have ownership and is not an officer, but when they talk, they wield power and control of that company, that person is somebody who has, quote, substantial control. Therefore, their information must be filed with the FinCEN. The 25% ownership determination, like I said, is traditional stock, voting and non-voting. If you have a voting trust, if there's just a profit interest or a capital interest that you have the right to distributions, if there's a convertible stock, sometimes in a rather creative entity, you might have somebody that has the right to convert a debt into stock, called a convertible debenture. You might have an option to purchase additional stock at some point in the future. If you have the ability to control up to 25% or in excess of 25%, you are falling into this category. The substantial control issue, again, a senior officer, president, CFO, CEO, COO, general counsel, or other important decision maker on the board of directors. If you can appoint, if there's some provision in the organizational documents that gives somebody the ability to have influence over the appointment of a president or a senior officer, that person is somebody with substantial control. And then generally just within the structure of the entity, you might have a lower level officer by title who is cloaked with authority to do practically everything. A general manager, for example, doesn't necessarily fall into the category of president, CFO, CEOs, chief operating officer, general counsel. But if that general manager by title has authority over the entire organization and they are basically running it, they just don't happen to have one of those specifically designated titles, they're a person with substantial control. Their information has to be entered into the FinCEN network. Now, what are some exemptions? The first, multiple bullet points, pretty obvious. If your company is large enough that you've registered with the SEC, or it's a government or quasi-governmental entity, a financial institution, bank, savings and loan, credit bureau, if you're a broker dealer, or you're registered on the Securities Exchange, an investment company, investment advisors, insurance companies, accounting firms, believe it or not, commodity exchanges, utilities, tax-exempt entities, inactive entities. Look at that bullet point, second to last one. If I've got a client right now that ceased operations 2 years ago, but they were just waiting to formally dissolve until this year so that they could get by the statute of limitations on 3 years post liquidation. We're not going to file a FinCEN registration with them because they don't own property. There's no cash in the bank. It's not active. Therefore, it's an inactive entity, and we're just going to dissolve it here in the next few weeks anyway. So we are not going to report that. If you are questioning whether or not, are you active, are you inactive, there's a set of standards in the frequently asked questions and the user guide for FinCEN. It's online. You can pull it up and get to it. But there's a series of 6 or 7 indicators as to whether or not you're an inactive entity. You better comply with that. If you try and skate by, as Ward is going to go over, there's some penalties for not complying. The last bullet point is an interesting one. You would think logically maybe that if the goal here is to get at the offshore Ponzi scheme, multiple shell corporation, multiple shell entity documentation to see who's doing what, that you would want to target the big companies. Quite the opposite. If you are a large company, you've got an address in the US, you've got more than 20 employees, and you have revenue in excess of $5 million, you're exempt. The only logic behind that I can see is that if you are a scoundrel trying to run the system and game the system and money launder and move things back and forth, if you're going in large denominations, it's probably a lot easier to have red flags go up when somebody is trying to scrutinize the electronic transaction network. You know, 5, 10, 15, $20 million transactions, those are going to stick out like a sore thumb. 200,000, 150,000, million, 2 million. Those might be more run of the mill. And that is my own personal opinion as to why the $5 million benchmark, if you're above that, you don't have to file. If you're below that, you do. Ultimately, and then I'll turn this over to Ward, is if, Suzanne, is Ward on the line?
I am. I'm
I
here.
don't.
Okay,
Okay,
good.
great, great, Ward. Thank you.
Some people are going to say, why are we doing all of this? And I guess I would hearken back to, if you think almost 100 years ago, think Al Capone. He was put in prison not for larceny, not for money laundering, not for running drugs and alcohol. He was put in prison for tax avoidance. So think about, if somebody's going after the scoundrels, the US government, Department of Justice is going after the scoundrels, they've got everything, almost what they need to get that beyond a reasonable doubt conviction, but they're just not quite there. So they go back and look at all of these companies that they found, these shell companies, and they find out, aha, this person or these people did not do their FinCEN filing. We can now pop them for 2 years incarceration for willfully failing to comply. Therefore, they can potentially go to prison, and they can go to prison on somewhat of a technicality, but that's the law. With that, I'll turn it over to Ward.
Thanks, Eric.
Thank you, Eric.
All right, let me see if I can share my screen here.
If you can't, I can pull it up and you can tell me when to shift the slides.
Can you all see that?
Yep.
Perfect. Okay. Yeah, thank you, Eric. Sorry for the delay in jumping on. I had a little technical difficulty, but I'm an attorney with Dorner, Saunders, Daniel and Anderson Law Firm. I'm located in Oklahoma, practice law in Oklahoma. And so Eric's kind of gone through all the different stuff about beneficial owners, the filing requirements. This is just a little bit more in depth about what must be reported when you make that filing. So that the specific type of information. And they've got a form that this information is input into, but it's basically the name of the company, address, date of formation, IRS taxpayer ID number, the identification of the beneficial owners that Eric was talking about, persons with 25% ownership or substantial control. And so, full names, date of birth, current residential street address, and then a photo ID, passport, driver's license, that type of thing. So it's pretty detailed information. And this information is filed with FinCEN. It's filed electronically. It's not a paper filing. They have some pretty detailed information about how to go about doing the filing. And as Eric said, a lot of CPAs, we have the same issue here in Oklahoma. The guidance for accountants was to not do it, generally because could be viewed as the practice of law. But certainly, owners of the companies and those that are running them can file it themselves, or you can contact your lawyer. One thing that's been an issue about is who has access to this information. How is it protected? So they've got specific rules and information about who can access the information. So it's, officers or employees of the government, individuals involved with, certain financial institutions, and they have to have a reason for accessing the information. So presumably, the goal here is to prevent, money laundering, those sorts of things. And so they'd have to have, some pretty good reason to access it. This page is pretty important, and this may catch a lot of people off guard. So this is a brand new law. Any entity that was filed, and this talks about basically when do you have to do this filing? When is it due? Anything that was, so an entity created before January 1 of this year, you've got basically this entire year to get the filing done. So sometime during this year, anyone that's a 25% owner or a beneficial owner of a company needs to make this filing. For new entities that are formed during 2024, you've got 90 days basically from the date that the entity is created within which to make the filing. Beginning in 2025, they're going to shorten that time period to 30 days. So they're giving us a little bit of additional time if you create a new entity this year to get the filing completed, but it's still not a lot of time. It's 90 days. There's also a requirement that if a change occurs in the ownership of the company, then the company's required to file a supplement report within 30 days of that change. And you can imagine that that could be pretty cumbersome if you're in a situation where ownership changes on a regular basis, bringing in new owners or a new board or new people that might have substantial control over the entity. Now, what happens if you don't file? Eric already kind of talked about this, but the law has penalties for not complying, and the penalties can be kind of severe. So if you don't make the required filing within those deadlines, they could impose a fine of up to $500 a day, up to $10,000. And there's also penalties for criminal penalties for violations, in particular willful violations or misrepresenting information, and that could include up to 2 years in prison. So very substantial penalties associated with it. And so, business owners need to be aware that this is an obligation they're going to have to comply with. Talk to your lawyer about it, figure out best practices, but it's something that will need to be done for existing companies within this year. And for any new companies that are going to be formed in the future, 90 days from the date that entity is formed. And I know lots of people will set up, LLCs for real estate purchases or a variety of business purposes, tax purposes, all sorts of things. So it's a pretty substantial change in the law and kind of puts an onus on the business owner to comply. The FinCEN website is listed here. It's got a lot of detailed information about what type of information needs to be reported, how to report, how to apply. But that's generally it in a nutshell. Does anyone have any questions for Eric or I?
Ward, I think Ray, are you on? Are you unmuted?
Yeah, I'm here.
I think Ray
And-
has a question.
Yeah, so if this is kind of like a delayed law from an original act or bill, are there other delayed laws that will be enacted later? Will you be following up on that? I don't know if my question makes sense there, but it seems like there's a lot that we're going to yet to see here.
Well, I'll take that one. Are there other laws that might be delayed? Yeah, maybe. I don't know what they are off the top of my head. Those things happen from time to time. This is the most recent one that I can think of. Several of us knew that this was coming, but we didn't know what all the details were. All the detail on the FinCEN network didn't exist prior to 1/1/2024. You couldn't even get at the filing. Even if you wanted to file, you couldn't file until after January 1, 2024. So it's one of those deals where, if laws get passed and there's an effective date, and if it's substantial enough, it gets out into the world. And yeah, I suppose we'll report on it when it comes up. But as to specifics, unless Ward knows something that I don't, I'm not aware of anything really substantive that's coming down the pike immediately.
Can I do a quick follow-up?
Sure.
So I have talked to a couple of local attorneys here, I live in Indiana, by the way, and
Interesting.
their
Hey,
approach
when you
is
need some money, I've
they're
got some.
advising their clients to wait till the latter part of the year to do these filings because there's their anticipation some more details and things and requirements are coming. Do you guys have any thoughts or opinions on that?
There, I'll jump in just briefly. So the law is, it's brand new. So there's not a lot of guidance. We've not seen a lot of people, do the filings. It's all, it's possible that people will file, people won't file that were required to file if they're creating new entities, and there could be guidance or information, from FinCEN about best practices. So it may just be that, anytime there's something brand new, a lot of times in the legal field, you look at precedent to determine kind of what are best practices for filing, what should be included or should not be included here. Because it's so new, there is no precedent. So in terms of, are they really going to impose a penalty? Where's the line for a something that's, an honest mistake versus something where someone was, trying to avoid some sort of requirement? There is no guidance on that. And so I could see a benefit to wait towards later in the year for existing entities to see if there's any guidance that comes out. But, I don't know that there's going to be any additional specific rules or guidance. It's just kind of, we might have more precedent and more experience to kind of use when those reports are done. But for new entities, if you create something today, you've got to file that within 90 days. You cannot wait. And so
Yeah.
for any new companies, you don't really have a choice.
Yeah, and along those lines, think back to when the HIPAA, the medical privacy law was passed in 2003. There were penalties potentially up to $250,000 on doctors who violated HIPAA. And so, like Ward says, if you wait till the end of the year, I can see waiting until the end of the year for an entity that was created before January 1, 2024. I've got several that I've got to do. I don't have time to do them right now. I got all year to do it. It'll get done. Entities that are created now, you got 90 days. And if you don't get it filed within 90 days, the question is, do you want to be the test case? Do you want to wait on whether or not FinCEN really is going to be serious about these penalties? My opinion is, I don't want my clients to be a test case.
Thank you.
Very, very good. Any other questions there, Ray?
No, it's good. Thank you.
All right. I believe Laura has a question. What about nonprofits that are not 501c3s?
They are not exempt.
So they
if
have to
you've
do
got-
it.
If you've got a nonprofit entity that is not falling under 501c3, and there's lots of 501 designations, but the designation that is exempt in the statute is 501c3. So if you're a C9, I think that's word C9. Is that a sports organization or something like that? I think
Yeah, I think so.
that's not exempt. So you've got to file.
Laura, did you have any other follow-up questions to that?
Nope, that answers that question.
All right. I don't see any other questions in the chat. Does anyone have a question that they haven't put in the chat that they have? We've got a few more minutes.
I see a question
Thank
from
you, Ray.
Kay. Do trusts need to file? No, trusts are not businesses. Trusts are not, quote, reporting companies. Trusts fall under their own set of rules and regulations. They are not companies because they do not register with a local Secretary of State. I say a state Secretary of State's office. There's a question here from Carrie, not nonprofit. I'm not sure I understand the question.
So my question was, what about subdivision of state government that are considered not profit, but they're also not nonprofit?
Well, if they're a government or a quasi-governmental entity, then they would be exempt. It's on that exemption list.
It depends on if what's classified as quasi-government, right?
Yeah, and then I don't have all the details off the top of my head on that. That's where you just need to go into the FinCEN website and pull up the user's guide. And I mean, I've got a copy of it right here. I can see if I can find it real quickly. But generally speaking, go to the user's guide. It's pretty good to find out what is meant by, in this case, a quasi-governmental entity. Any other
Yeah,
questions?
those are things that, you know, the FinCEN guide will have some guidance on potentially. But if it doesn't qualify under one of those listed exemptions, then, you know, I would err on the side of caution and file.
Here's what it says on governmental authority. If an entity qualifies for this exemption, if both of the following criteria apply. One, the entity is established under the laws of the state of Kansas, an Indian tribe, a state, or a political subdivision of a state under an interstate compact between or two or more states. If yes, and if the entity exercises governmental authority on behalf of the United States, the Indian tribe, the state, or the political subdivision. If the answer is yes to both of those criteria, then you are a governmental, quasi-governmental entity. If the answer to either one of those is no, you're not exempt. You got to file.
And where did you reference that from? I'm sorry.
That's in the small entity compliance guide that is on the FinCEN website. You can pull down. I just opened it up as a PDF and printed it so that I had it for reference.
Eric, I have a question. I
Okay.
just started an LLC for myself, so I know I'm going to, and that was in January of this year. So I know I fall in that 90-day time period that I need to file, correct?
Correct.
How do, and this is the first time I've had an LLC, so bear with me on this question. How are people notified? How are businesses and LLCs and anyone who's impacted by this, how are they notified that this is enacted and they need to take action?
Well, for example, I've had several clients that have received letters notifying them of this new requirement from their accounting firm. Our office, I personally sent out probably close to 500 letters to clients, and sometimes it's going to be a pain in the neck because I have clients that have 4, 5, 6, 7 entities. And each one of those entities has to file. It's not just one that files for all 7 entities. Each entity must file.
Gotcha. Good to know.
Hopefully accountants and lawyers are sending information to their clients. Now there's going to be a certain, like Ward mentioned, there's going to be a certain segment of people that created their own single member LLC. They do their own accounting. And if they're not up on or getting information where they need to get it, they might be asleep at the wheel and they might miss it. That's where Ward is correct in saying maybe later on this year, there might be some information that comes out saying, okay, folks, an inadvertent mistake, or you just didn't get it done the first time. That's okay. Shame on you. We'll overlook it this time. But again, if you willfully say, I don't like the government knowing anything about me, kick rocks, you do that at your own peril.
Right.
And
I just was curious how people were notified of that. I work with a CPA, but I mean, I just started all this. Do CPAs get notification of these things?
Oh, to kind of answer that a little bit more. So there's not really a general, hey, everybody gets a letter or a notification about this change in the law. And there's some conflicting information because it is so new about who has an obligation to notify whom about this. So just kind of in general, you know, a lawyer doing legal work for someone, they don't have a continuing generally obligation to notify those, you know, former clients about every potential change in the law. So now if
Right.
you have an existing client or you're doing work with them over something that might be covered by that, then you might expect to get, you know, notified, you know, by someone you've worked with. But absent that type of a relationship, FinCEN is not sending like notices. The states aren't sending notices to people. So these would only be like a relationship type of a situation where, you know, you had a relationship with a lawyer or a CPA, and you might expect them to do that. But there are a lot of CPA firms that are, because this is considered the practice of law, are not going to send notifications. And a lot of law firms are not necessarily going to send notifications to everyone they ever did work for. They might send, you know, notifications to clients that, you know, those clients might have an expectation of being notified about that. But generally speaking, you know, lawyers don't have necessarily a continuing obligation to notify everyone that, hey, there's been a change in the law. You should know about that.
So the
But
best
it kind
place
of falls
for
on the business
people,
owner.
Just,
So the-
just like
yeah, so-
Ward, I don't know what Oklahoma's doing, but Kansas Secretary of State's office has, if you log into their the Secretary of State, they've got a ribbon that talks about FinCEN and filing that's just, you can't log into their office without seeing that.
Yeah.
And then
Oklahoma has the
like I
same
said,
thing.
with
They've got a deal on their website to notify you know, people that are making filings with the state of Oklahoma about the change in the law. And you know, our firm website, you know, we put like information on there about the Corporate Transparency Act. And lots of lawyers are sending letters, or, you know, but it just depends on different types of people have different practices. And so I would not, as a business owner, necessarily expect that you're going to be notified by someone.
so you just need, is the best place to go is to the state?
I would go to the FinCEN website. That's
Okay,
got the most detailed information because it's not a state filing, it's a federal filing directly with FinCEN.
right.
great.
And along the lines of my sending out letters, I only sent them out to my current clients. I did not send them out to entities for whom I don't do any work for anymore.
Gotcha.
And,
Thank
and,
you.
and that would be the case with most lawyers, I would expect.
Yeah,
Yeah.
that makes sense. Thank you. That's helpful. Anybody else have any other questions? I did put my email in the chat. If you think of questions that were not answered today, feel free to email those to me and I will get those answered for you. So Eric, thank you.
All right.
And Ward, thank you. And thank you for everybody who participated. Thank you, Matt, for your assistance. And unless there's other questions, I think we're done for the day. Everyone enjoy the rest of today.
Very good. Thank you all.
Thank you.
Thank you.
You.